Welcome to We Don't Color on the Dog. We've got with us Chris Crawford, who represented Stan McDaniels in what has become the case that overturned the state's open carry prohibition. And we've got Chris with us now. Chris, thank you for doing this.
You guys are welcome. I'm very excited to talk more about it. It was a long road to get here. There was a
Mm-hmm.
lot of people who said we were wrong, and we're very excited about the opinion, and I think it was a very well written opinion.
Talk just some of the basics of the case for viewers who may not be familiar with it.
So essentially, what happened is Mr. McDaniels was running for a political office in Escambia County on a day, July 4th. It was a weekend day. Courthouse was closed. He's down on the corner of Balin and Main Street. There's kind of a grass area down there, and he's holding out signs promoting his race in the election. When he's doing that, he had a handgun in his waistband. He had a t-shirt on, and at times you could see roughly 3 to 4 inches of the handle of the handgun. He wasn't down there with any intent on getting arrested. He himself personally believed that the Second Amendment gave him absolute right to carry a firearm. He had a concealed carry license. He was legally allowed to carry a firearm. He wasn't doing anything illegal at the time. And what happened is someone just passing by, presumably driving by, saw the butt of the handgun and called PPD. Officers with PPD arrive. They talked to him about it. They honestly tried to dissuade him to just cover up the handle.
Mm-hmm.
And he kept on saying, I don't have to. Here's the Constitution. He had the Constitution in his hand. He kept on saying, here's the Constitution. And they ended up arresting him for a second-degree misdemeanor, openly carrying a firearm. So I see it on the news because it was in the news. Everyone thought, what a kooky kind of knucklehead thing to do. I didn't really think anything of it. Before this case, I wasn't personally interested in gun advocate rights. I believe in the Second Amendment. I own firearms. I've always, from a young age, had firearms. I grew up in a kind of rural area, but I wasn't, someone who was well read on the history of gun laws or anything like that. Well, what happens in this case is I get a call from a gentleman named Eric Friday. And Eric Friday is by far the scion, the genius of Florida gun laws, national gun laws. And Eric Friday, for roughly 15 years, has been going around the state of Florida saying, you guys are wrong. Open carry is actually the constitutional method of carry. So there's all this talk about confusion with the law now. Candidly, I think that is really more about setting up the legislator to come in and try to walk back this case. What this case did, from some people's viewpoint, is it gave more rights back to the citizen. It kind of set a curb on where the government interacts with your life. Well, sometimes the government doesn't like that. So all this talk about confusion and what this sheriff is going to do and what that sheriff is going to do, there's a part of me that believes that this is kind of setting up this stage for the next session where they're going to try to tinker with the law and walk it back. It was never a good law. It was always broken. And why it was always broken, why it was never a good law, was because it was always unconstitutional. Eric Friday, this guy, he calls me late at night. I'm at my office and I'm on the phone for about 3 hours with this guy. We're going through all these cases and statutes and cases all over the country. And during that conversation, I realized this guy was right, that he was 100% right, that open carry is the constitutional method. That's all we're talking about, is simply the method of carrying a firearm if you're otherwise legally allowed to do so. That's it. Okay, so all this confusion is not about this decision. It's really because this law was messed up from the beginning. When we did this licensing scheme and where you could go, where you can't go. Under the old law, if I brought a shotgun, if I brought my grandfather's shotgun down to the gunsmith on Garden Street, who's probably one of the last master craftsmen we have in this city, if I'm walking that shotgun into a store or out of the store, I was committing a crime. That's how the old law was written. It was ridiculous. It was really a political deal between the NRA and the state of Florida, and it was never workable. So taking you back then to this phone call with Mr. Friday, I realized that he was right. I realized that open carry was the right constitutional method. And yet again, this is not me being someone who's a large gun advocate, I just knew that that was right, and I want things to be orderly. I want things to harmonize correctly in law. It should, and that did not. So I agreed to then represent Mr. McDaniels.
You were unsuccessful at the trial court level.
Yeah.
Sort of an appellate. I think doing at the appeal level. Well, let's talk about the trial itself. Talk about that.
So this is the other thing that I would love for everybody in the state of Florida to realize. Mr. McDaniels was charged with a second-degree misdemeanor. The vast majority of the time, no one is going to jail for a second-degree misdemeanor. Okay? At any point of time, the Escambia State Attorney's Office could have dismissed this case, right? They could have dismissed this case, and we would have never had this opinion that now completely changes this constitutional law. But they didn't do it. And the reality is Eric Friday represented people in other counties where when he would show up in the case, they would dismiss it because these other counties did not want it to go the way that it went here. Our county, luckily, the one thing you can guarantee is there ain't dismissing any cases. So it was very odd, the conversations that I'm having with Eric, that all they would have to do is dismiss a second-degree misdemeanor, of which the guy was never going to go to jail for in the first place. They didn't do it. And then we have a trial, and this is probably one of the first trials in my life, where part of the things that we're trying to do is actually not win the trial. Because if we would have won the trial, we would have never had the ability to appeal. And that was a very unique thing. I'm not saying that I intentionally threw the trial. It's not at all what happened. Mr. McDaniels candidly wanted to win the trial there in the moment. But that was one of the things that was also in his mind is, hey, we have to make sure that the record's correct. And there's things that we're doing to make sure the record is accurate if there's an appeal.
So really,
go ahead.
That's what I was leading in the beginning, was thinking you really needed it to go to the appellate level to be able to have a ruling that had the weight that this one does.
Yeah, and early on, we tried to make an agreement with the state attorney's office just to allow us to go to the appellate level, that we're not going to have to do the motion hearing and the trial. But those guys said no. And one of these unique things is in the practice of law, there's different levels of, gamesmanship is the best way to put it. That decision really hurt them, because then when we went to the appellate level, we had this full history of the record that gave the appellate court more context. The first sentence in the opinion discusses a man who's not doing anything wrong, who is doing this whole story about, he's trying to run for an election. All that was there because they didn't agree just to let us go to the appellate court.
It didn't. It was a unanimous decision, Chris.
Yes.
So this was, and I think what we're seeing is the confusion is what to do about the concealed carry law, which now seems to be completely unnecessary. And then the prohibitions, those 12A exemptions that are out there, those, what to do with that. How do you see this?
So my belief is what we're talking about in a very base level is what can the government regulate and what did they regulate historically? So the way the law works in this particular area is this right historically was the ability to defend yourself against someone else doing you or your family harm, but also importantly, the ability to defend yourself against a tyrannical government. That seems to be left out of the conversation a lot of times when we're talking about the Second Amendment, but that's why it was there. So what happened in a very important case called Bruin, which was a case out of New York, is Judge Scalia, who should go in history as one of the greatest jurists of our country, had a discussion. He was a Supreme Court judge. He had a discussion that up until this time point, we've been doing this balancing, dealing with Second Amendment, whether the government's interest outweighs the interest of the citizen. And what Scalia basically said is, we're dealing with a right that has this inherent story of fighting the government. So why would we then allow the government to do this balancing? What their interest would always be to balance the scale on their side, knowing that this right would be presumably, there's this world that the right could be used to fight citizen to government. So he said, we're not balancing anymore. What we're going to do is we're going to go look back at what the historical regulation of basically firearms were. And if it wasn't a historical regulation, we're not going to allow it. So historically, there were places that you could not bring a firearm? And is it best practice when we talk about the courthouse and the sheriff's office and government buildings? The federal has their own law about their own buildings. Is it best practice that guns not be allowed in these places? Absolutely. The problem that the legislator did, and this was an intentional problem, is they tied it to this licensing scheme, a licensing scheme for which they controlled, for which they got paid. And they should have never had that ability. That's where the government interferes in your life, that they never should have had that power. So when we're talking about this concern about these places that individuals may have a firearm, the best practice, and what I would say as the individual who was actually there in the court level arguing that this was unconstitutional, is those places still apply. All we were talking about was the method with which someone carries a gun. And the idea is, look, people online, they're going to have their own comments. You got a lot of tactical Joes out there who want to give you their tactical knowledge. But historically, the only people who carried weapons in a concealed manner were people who were planning on doing bad things with them. If you were not planning on doing something bad with something you had, why would you not just show it openly? And that's historically what the law said. It was that the ne'er-do-well, the thug, the person up to no good would be the person who's concealing the gun. The person who is doing something lawfully, who has no concerns, would have it openly. That's the only thing we're talking about. So the location aspects, those, in my opinion, still stay, even though they're under this insane licensing scheme. And these different locations that were always protected as being places where you could historically not carry a firearm, you shouldn't carry a firearm there. And it's perfectly fine to say that's illegal. It still is illegal. And I have no issue with any sheriff in any county enforcing that. All we're talking about is the method of carry.
Well, there's a reason why you keep winning best to the coast, best attorney.
Yeah, that's what they say.
This is such an important case. Talk about just being a part of a case to finally, I mean, not finally, but one that really is changing Florida right now.
So when we went to the appellate court, when they allowed us to do oral argument, which is very rare. So when people see on TV these lawyers in whatever movie arguing with the court, that's rare. That doesn't happen. Normally, the appellate court can make a decision on what's already written down. So we knew we had a chance when they allowed argument. And then here's one of these unique facts that you have to be there to really understand it. We were originally set to go to the First District Courthouse in Tallahassee. It's a big, beautiful, fairly new building. And then they changed it. We get this notice that essentially says, we're going to change this to the Florida State Law School building. Now, I didn't know this until I was actually there, but the Florida State Law School building has a part of the old Florida DCA.
Oh.
Okay, so the courtroom that we argued this was, let's just say, the original DCA courtroom. And what they did is they wanted important constitutional cases to be on showcase for the Florida State law students, and it was filmed. So we're there in this old wood panel building that I'm being told, hey, this was actually the original courtroom. This was the old first DCA courtroom that the Florida State Law School was allowed to then essentially take over and use. So we knew being there that somebody considered this important. And then while we were there, the questions that are being asked in the way that the judges see this issue, in the way that they saw it candidly, this wasn't like a discretionary decision to them. After the Bruin case was decided, this very important case that says we're no longer balancing, the judges essentially said, our hands may be somewhat tied at this point. Because the state, again, if they would have just made this deal with us, this may not have ever happened. But at these hearings that the state insisted that we move forward with, they did not present a single historical case that said concealed carry was right, open carry was wrong. So even the judges are looking back at the record from the trial level and saying, there was nothing here, guys. Y'all didn't do this. And that would have never happened if they would have just made this deal, which they refused to do. So I left the hearing feeling in awe. I mean, it was to describe the judges as the professional, a professional league. Even the professional league, if you think of it in a sports context, may not even apply. I mean, these are people who absolutely should be there. Brilliant people. They were very professional, gracious. It was an amazing moment. But I'm leaving and I'm calling another local attorney here, a gentleman named Jason Cromie, who does a lot of appellate work, and I'm saying, I think they may actually agree with us. And can you imagine what that's going to look like if they agree with us? That's what happened.
That's great. That's great. Chris, thank you for sharing the story. I really
Absolutely.
appreciate it. Thank you for reaching out.
It was a wild time. It was a wild story, and I would have never thought, seeing it in the news, this guy getting arrested, that I was going to be involved.
Chris, thank you so much for doing it.
I appreciate it.
I'm sure we'll have another case that we'll cover soon, but thank you.
Yeah, I mean, you and I, we're not getting younger, so, but I'm sure we will.
It's hard to believe you're older than me, but, I'm in news.
Exactly.
It's different. Thanks, Chris.
Thank you. I appreciate it.
Thanks for watching, and to keep up with what's going on, be sure and subscribe. Just click on the little dog to the right and click the subscribe button. You can also like this video and click on the bell, which will notify you of new content. This really helps the channel grow. We appreciate you.